Court is calling 2023 CR 3442 State versus Robin Huerta Hernandez. Can I have parties announced for the record for the state? Defense?
This is Pauline Portillo for Ms. Robin Huerta Hernandez.
And are you Ms. Hernandez?
Yes, ma'am.
All right, and you need to slide over a little bit so that the state will have room. All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Robin Huerta Hernandez who was placed on deferred adjudication in 2023 CR 3442 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on August 17, 2023 for a period of 2 years? Is that you? All right, state.
Your Honor, we wish to proceed on violation of condition number 4 in Bexar County, Texas. The defendant, Robin Huerta Hernandez, did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, and September 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainders.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? You need to speak.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? All right, so here's the thing. Let me explain this to you. You've entered a plea of true to violation of condition number 4. Maybe you and your attorney have worked out an agreement with the state. I don't have to follow that agreement. The reason why I don't have to follow that agreement is because you don't have a contract with the state or with your attorney. The contract is with the court, and that contract is your conditions of probation. So by pleading true to violation of condition number 4, I don't have to follow any agreement that has been reached between you and the state. It's just a recommendation, right? So you're looking up, I could revoke you and sentence you to 2 years. I could send you up to 10 years and I can sentence you up to $10,000 fine. Do you understand? Knowing that, do you still wish to plead true to violation of condition number 4? All right, do you want to step back and talk to her some more?
Yes.
Yeah.
Okay. Yes, Your Honor.
Sure. All right, we are back on the record and cause number 2023 CR 3442. State versus Robin Hernandez. Can I have parties re-announce, please, for the state?
State.
This is Pauline Portillo for Ms. Robin Huerta Hernandez.
All right, and you're Miss Hernandez? All right, so you had entered a plea of true to violation of condition number 4. The court explained to you what the implications of the plea of true. And I gave you time to confer with your counsel. So do you still wish to plead true to violation of condition number 4? Do you understand by pleading true to that violation, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. And is there a proposed agreement?
Judge, so there's not really an agreement. Each side's asking for something different. As far as the state and what the state is asking for, we are asking that you deny the motion. However, we're asking for you to alter and amend her condition. We'll continue her on deferred, but alter and amend her conditions for a 1-year extension and order her to go to safe P. Due to the struggles that she has had with reporting and failing to submit to her UAs.
All right, defense, what are you requesting?
Judge, we're asking for the extension of the 1 year as well, but instead of safe P, we're asking for some form of supportive outpatient treatment. Since Ms. Huerta Hernandez was released, she's been doing almost daily NA meetings online. She's been checking in with Ms. Lanier, her pretrial supervision officer, which I have an email from her in Defendants Exhibit 1 that she's been in full compliance, no violations on her GPS.
Any
I
objection
have
to?
a chance to review it. I have no objection.
All right, I'll review that.
And the MTR alleges drug use in February, but there have been no positive tests since then. I do intend to call Mr. Mike Hernandez, her fiance, and Miss Hernandez herself to explain the non-reporting. I urge the court, if they're between making a decision between safety and what I'm asking for, which is a supportive outpatient program, that they send Miss Huerta Hernandez for drug testing. I do believe she's going to come up negative. And I do believe that I'm gonna put on some evidence.
So why hasn't she been reporting?
Judge, it seems like around the time that she stopped reporting in March, she was dealing with some homelessness. And she recently connected with her fiance, and she's now living with him, which was not a circumstance back when she stopped reporting. He's been keeping her on track, helping her to get clean, helping her to look for employment. She has been a victim of abusive relationships in the past, which have caused complete destruction for her. She's lost custody of her children. It's caused drug use. It's led to a diagnosis of bipolar disorder and depression. And so at this point, I think she is in the best position with the support of her fiance, with the support of her fiance's mother, who have been waiting here all day for her. And I think she's just right on track, Your Honor, to not relapse again. She's been doing everything she's supposed to do. She's she also has some medical disorders that I think are gonna cause a problem for her if she had to go back into detention. She has a little eye infection, if the court could take notice of. She has a cut eye that I think she needs to get treated pretty soon, and she has asthma that she said was very difficult for her when she was in SATIF. And Your Honor, I think just the circumstances for her right now are gonna be optimal for her to succeed and not relapse. She has no criminal history besides this case. So at this point, I'm asking you, add conditions, weekly UAs, random UAs, zero tolerance, can keep her on GPS. She would like to look for work as a housekeeper at this point to help contribute to the household and get some visits back in. She has ordered supervised visits through Guardian House right now with her 16-year-old. So she really just wants to get her life back together and get back on track.
I'm sorry, what did you say about her and a 16-year-old?
She's supervised visits at Guardian House right now. They cost quite a bit of money though, so she will have to work to try to get those visits in. But that's my understanding from what she tells me is going on with that minor child. She does have older children as well. They're adults. They were here at the last setting, but as far as just the minor, she really has to rebuild that back up because her past relationships have really caused havoc in her life
Okay.
and have led to these behaviors.
And state.
Judge, I am in agreement. This is her first MTR. She doesn't have any additional criminal history other than this. However, she has had some issues reporting, and I just think she needs a more structured environment to really help her if she's really serious about getting clean. She did complete SATIF, but did struggle in aftercare, and then just kind of falls off the grid, absconded from the jurisdiction of the court. And there haven't been any positives because she hasn't submitted to UA. And so that's why I'm asking for what I'm asking for, Your Honor.
And Judge, I meant to tender Defendants Exhibit 2 also, which is the verification that she's been attending the NA meeting. Mission and published to the court.
Yes. If you drug tested today, what are the results going to be?
Negative.
All right, you're going to go do a drug test today. Bashan, she's going to go do a drug test with felony drug court. So if you could have her go, and I'm going to send you some information of who to contact, and they're going to want a photo ID. So if someone can, do you have a photo ID?
I don't, Your Honor.
Oh, they can take a photo, somebody take a picture of her and give it to them. Just send it. All right, we're going to come back with this. And she's in custody because she's late, correct? And you're on GPS and you're late. Why were you late?
There was a long line outside, Your Honor. To get in on the courthouse, I was
All right,
here.
So deputy, what we'll do is we're going to release her so she can go and do her UA. All right?
Judge, will she be brought back here today? So should I just go ahead and
Oh,
wait?
no. Yes, wait. She's going to go straight over there and she's going to come straight back. Her fiance is here. I'm sure he can drive her.
Yeah, sounds good.
Okay.
Oh, I'm sorry, but her counsel, I should wait, right?
Yes.
For her to come back. Okay.
And if you. All right, we're going to go back on the record. And we're back on the record in cause number 2023 CR 3442. Could I have parties announce for the record, please, for the state? Defense? All right, and this is State of Texas versus Robin Huerta Hernandez. You entered a plea to violation of condition number 4. You entered a plea of true. The court ordered a UA, and you informed the court that you would be negative. I'm sorry.
Want to do that, and I already did it to me, and asked for you to make these, and I do want to change. I am changing. I have changed. People have places and things. I do have support now, family support, and nobody knew. I thought it was quick about me, and I'm sorry for lying. I do want to change, but I thought it I am, and I want to be in my daughter's life.
All right. All right, is there anything else from the state or the defense?
Nothing.
All right, you've been missing for many months. That's what your plea of true was. I was informed that you were going to be clean, that you've been doing great work, but you were not clean. The court is going to grant the motion. The court is going to find you guilty. The court will revoke, request the therapeutic community. How much time are you asking for, state? Defense, what are you asking for?
I heard this Polo say that she admitted to drugs before she got there, so she did take that responsibility. She considered you're asking for it that you're.
All right. The court will sentence you to 3 years in the prison, give you credit for any time served, and the court will retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. I will tell you in this court, with regards to drug use, honesty is always the best policy. All right, good luck to you. All right, on this case, where are we on discovery?
I don't believe I received discovery on the fentanyl case. There's 2 cases, an arson case and a
Okay.
fentanyl case. They're separated by time.
All right, let me find the. Yes, and are you the prosecutor on both criminal trial
Yes.
division?
And we've been talking about trying to work them all out. Judge.
Mhm.
I didn't know about today's setting until Thursday when her dad called me. I did not get a written notice.
Oh, no, there was a judge's warrant that was issued
Okay, so,
on the arson case. So of course, once a judge's warrant is issued, we try to get them in the court as quickly as possible
okay,
to
I
address
just
that issue.
wanted a
So-
little more notice from the family telling me be there in 2 days.
Okay,
My client's terribly upset that I can't talk to her face to face.
all right, so let me explain something to you, Ms. Cameron. So you had a violation report. The reason why you had a violation report is not through this court, it's through your supervision. And that was through the supervision of the pretrial services. And so they sent the court a violation report. You're charged with stalking, and they are saying that they've attempted to contact you. You would never respond to them. And in it, they tried all of the references that you had listed, and they were not able to contact you. So what ends up happening, because of the nature of your offense, a judge's warrant was issued because nobody knows where you are, and it's important that they know where you are. Now, once a judge's warrant is issued and you're remanded without bond, that means that no bond is set. So we try to get you in court as quickly as possible so those issues can be addressed, that maybe you can get a bond. Your attorney, usually they're given more notice than that, but you're at the Bexar County Jail. You're in custody. I know that anytime someone's at the Bexar County Jail, even if it's for 2 minutes, that's a lot of time for them. So we try to get you here as quickly as possible. So it's not your attorney's fault. The court just wants to get you in here as quickly as possible, okay? So, where are we on discovery?
I don't believe I've had discovery in the fentanyl case. That's why it's such a surprise to me.
Okay,
And the report contained in that key trial is very handy. This says a search incident to arrest of the car
okay.
found in a purse.
So basically the highest level felony is the arson?
Correct.
Yes, Judge.
All right.
And so the discovery has been tendered via our e-discovery system, and I did make an offer, a global offer to Mr. Hyatt.
Oh, I'm sorry. And I do have discovery in the arson.
Okay. All right, how old are you?
37.
All right. And are there any mental health issues or anything of that nature?
She's very reluctant to do things like talk to me, not face to face, and that I'm not used to. I haven't figured out that's a mental issue though.
Well, I mean, sometimes people want to see people's face when they talk to them because you get to read them. All right. So let me ask you this. Have you ever been diagnosed with any type of mental health issues? All right. So then what I'm going to do, and the reason why I'm asking that question is because if there needs to be some examination by a doctor, I'd rather for us to get that out of the way than wait till the end and then need examination for doctor. So what I'm going to do is I'm going to set this for a plea deadline date in 30 days. Here's the thing about that 30-day setting. If your attorney wants you brought over sooner than 30 days, he can have you brought over sooner. If he wants to address the bond issue, he can have you brought over sooner. He'll have to file the motion and that'll be completely up to him. You understand? All right, Ms. Ferguson, I need a 30-day reset on Cameron for a plea deadline date, please. All right, so we'll come back on February 13th. And again, if your attorney wants you brought over sooner, all he has to do is let us know. Do you have any questions?
No, ma'am.
All right. Thank you.
Thank you, Your Honor. May I be excused?
Yes. All right, who's here for Leslie Miers?
Ready, Your Honor. Before we get started, good morning and happy new year.
Good morning. Happy New Year. All right, court is calling 2023 CR 10986, State of Texas versus Leslie Miers. Could I have parties announced for the record for the state?
Alexandria Bogus for the state.
Defense?
George Schaefer for defendant, Your Honor.
And are you Leslie Miers?
Yes, Your Honor.
And am I pronouncing your last name
Yes,
correctly?
ma'am. Thank you.
Sure. Did you review, just one moment. All right, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Leslie Dawn Miers who was placed on deferred adjudication in 2023 CR 10986 for the offense of assault family second offense on December 13, 2023 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 24B on or about the 15th day of November 2024 in Bexar County, Texas. The defendant, Leslie Dawn Miers, did then and there find herself in contact with Benjamin Guild and threatened, assaulted, or verbally abused said person in violation of condition number 24B.
To that, how do you plea? True
True.
or not true?
True, Your Honor. The state waives the remaining allegations, Your Honor.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of 24B, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to proceed with your plea of true to 24B?
Yes, Your Honor.
Court will find 24B true. All right. Is there a proposed agreement?
There is, Your Honor.
The proposed agreement is that she be sentenced to 2 years TDC.
All right, so has she done anything on probation other than threatening someone?
She said a bunch of negative UAs, Judge.
I finished my fifth class as well, and I did my 90 and 90, and I did about 3 to 4 meetings weekly. I was about to start my community service.
All right, and Benjamin
Guild.
Guild, is he the complainant in this case?
He is, Your Honor. And he's present in the courtroom.
All right, does anybody want to call him as a witness? Because I don't think that, okay, I don't think that 2 years is appropriate in this case. And let me explain to everybody why. It's because she's on probation for assault against the complainant. And then 24B is, I don't know, assaultive language or threats against the same complainant. So I don't understand why it should follow the agreement. That's what I'm asking.
Judge, I'll call him as a witness.
All right. Mr. Gill, if you can come forward, please.
Myers.
Right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Benjamin Holmes Guild.
All right, defense.
And you are the same person who was the complainant in the original case that she was put on probation for?
Yes.
And you are the same person who has alleged that on November the 15th of 2024, she committed another assault against you, correct? Now, at the time, were y'all drinking alcohol? She's not supposed to consume alcohol. You're aware of that?
Correct.
Same thing with you. You're not supposed to consume alcohol. And that's because we're on a probation yourself.
Indeed.
And what was the nature and extent of this argument? What happened?
I'm not sure of the details, to be honest. Call the details.
You were arguing with her?
It's probably mutual.
She was arguing with you?
It was probably more me than.
You understand that the state is recommending a sentence of 2 years. Are you amenable to that, or would you accept that?
Define amenable.
Well, are you happier than the court saying, no, I'm not going to accept that offer and sentence her up to 10 years?
I would rather that not happen. I would rather she get less than 2 years.
How long have you and she been together?
On and off for. She's been down here for 8 years. We've been acquaintances for 20 years, 20 plus years, 25 years.
And I'll pass the witness.
All right, any questions?
I have no questions.
All right, thank you. All right. This is, if there's nothing else from either side, this is what the court is going to do. Court is finding
24B.
24B true. The court will grant the motion. The court will find you guilty, give you credit for any time served. There's an affirmative finding of family violence. There should be no contact with Benjamin Gill. I'll request the therapeutic community for you, and the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Do you understand? Right. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Thank you.
Judge will give notice that we intend to
All right,
appeal the court's decision.
okay,
I mean, I've made a recommendation. You don't have to follow it. But
okay.
I
All right,
think you should have.
all right, thank you.
Judge Miers, Coach.
Yes.
On Hollingsworth, I conferred with, the prosecutor on that.
Okay.
But I just want to let you know, he's not here physically. I thought he was in county court 9 because he has a pending misdemeanor,
Okay.
but he isn't. Are you gonna need him here?
All right. Just give me one
Okay.
second. Let me put this down and then I'll take your Hollingsworth matter up.
Thank you, Judge.
You're welcome.
May I try to?
Just give me 1 second. Yes.
I'm not trying to cut in line, but 399 said they're bringing in jurors and I don't know.
Oh, go to the 399.
Well, I just got a response with an affidavit that may change the hearing that we were requesting. I'm just
Okay.
asking if we can possibly move it to later in the week or even next Monday. So,
Sure.
Okay,
All right.
and I'll get with Norma on that.
Okay,
Thank
all
you,
right.
guys.
Thank you. Sure. Oh, no problem. Sorry, that goes with that.
Oh, thank you, Judge.
All right, Hollingsworth. File on Hollingsworth.
There's no file, Judge. It's a pre-filed case, but it's already been assigned for some reason.
Right here, Judge.
All right, yes.
Judge, Your Honor, he's been in custody beyond 90 days without indictment.
Mhm.
So we're asking the court for a PR bond,
Mhm.
on this matter.
All right, so Miss, we'll still need to have a hearing. Miss Ferguson. On this one, see if he can be in by Zoom or either we can have him here tomorrow.
Okay.
All right,
Either or.
Okay.
Thanks, Judge.
you're welcome. Mike Hernandez.
I'm representing Mr. Hernandez. Miss Mulliner is on the other side. It's a white collar matter. Apparently, there's some volumes of discovery. It hasn't been tendered over. So we communicated with her and we found out late on Friday that she was out. And so she's working on getting the discovery
But
today.
where's your client?
I will get him over here because I think on Friday I told him, you know what, I'm gonna visit. We're gonna reset it because we don't have any discovery. And I wasn't able to get a hold of him yesterday, but if I can.
But is he on the docket today?
He is on the docket today.
And
I
he's
was-
not here?
And I communicated with Miss Ferguson. I can get him here. I can get him here.
No, I mean, he's supposed to be on the docket today. Was he reset?
No, that was the goal. I communicated with Mr. Hernandez. I said, we don't have any discovery. I anticipate we can get this matter reset. That was the last of it until I remembered Sunday. But if I need to get him here, I will certainly get
Oh,
him.
he's on the docket today. He may be taken into custody.
He will be here today in just a little bit. And so, but could I ask for, because we don't have any discovery, for it to be bumped back 30 days or something so we can,
Well, I can't do anything until your client
I will
appears.
get him here, Judge.
Okay.
All right, thank you.
Kelly Cotner. Court is calling 2024 CR 6359 State versus Kelly Cotner. Because I have parties announced for the record for the state defense.
George Sharman on behalf of Ms. Cotner.
And are you Miss Cotner? Yes, ma'am. All right. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. And counsel, I'm assuming you signed this on today, the acknowledgement of discovery?
Yes,
All right. It's just that you have the years 2024.
sorry.
That's okay. It's gonna happen a lot.
Yep,
All right. Court will find that the state is in compliance with discovery. Ms. Cotner, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
we do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving the habitual offender enhancement allegation.
Any objection?
No objection.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Well, all places. Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine.
Yes,
Did you review the plea bargain page with your attorney? Did you understand it?
yes, Your Honor.
According to the plea, punishment is to be assessed at 8 years in the prison. The state recommends community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
It is.
State is at the plea?
Yes, Your Honor.
All right, outside the agreement, the state is recommending that your community supervision be for a term of 8 years. There be a TAP evaluation, 10 days in the Bear County Jail as a condition, DWI intervention, victim impact live and ignition interlock for half the term. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And we're off the record. All right, we're going to go back on the record. and 2024 CR 6359, State versus Kelly Cotner. All right, it's off the record. The state would like to introduce or tender another exhibit with regards to the stipulations. Defense, have you had a chance to review the
I did,
added
Judge.
stipulations?
I did.
Do you have any objections?
I have no objection.
Ms. Cotner, do you have any objections?
No, Your Honor.
All right, then the court will accept into evidence the added stipulations, and the court will review those. All right, and state, you may be excused. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. I'm going to set this off for sentencing because I need a TAP evaluation. Would you like a full PSI or just a TAP evaluation?
Well, let's do a whole PSI.
All right.
I think that would help you in the final sentencing.
All right, Ms. Abrams, this is going to be set for a PSI and a TAP evaluation. And could you also do a referral to felony drug court? Ms. Ferguson, what date? March 10th? All right, we'll be back on March 10th. At that time, I will let you know whether or not I'm following the plea bargain agreement. And if I do follow the plea bargaining agreement, at that time, I'll set conditions for you. My decision will be based upon any evidence that's presented to me. Do you have any questions?
Oh, Your Honor.
All right, thank you. We'll see you then.
Thank you very much.
You're welcome. All right, court is calling 2024 CR 3163, State of Texas versus Enrique Soriano. Can I have parties announced for the record? State,
Andrew Harris, Tatum.
defense.
Sherman on behalf of Mr. Soriano.
Are you Mr. Soriano?
Yes, Judge.
It's counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Soriano, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney?
Yes, Judge.
Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Did you understand you're charged with driving while intoxicated, third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Judge.
Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Judge.
According to the plea, punishment is to be assessed at 4 years in the prison, and the state is recommending community supervision. Did you understand that to be the plea?
Yes, Judge.
Defense, is that the plea?
It is.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Judge.
Did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There be a TAP evaluation, 10 days in the Bexar County Jail as a condition, 200 hours of community service restitution, DWI intervention, VIP live, and ignition and interlock for half the term. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. I'll set this for a PSI and TAP evaluation. Ms. Ferguson, can we put this on the same date as Cotner?
Yes, March.
All right, we will see you back here on March 10th. At that time, I will make a decision on your sentencing. Do you have any questions?
No, Judge.
All right, probation will give you instructions.
Thank you, Judge.
All right, thank you.
Have a seat right over by probation. I'll get you a slide.